A bylaw is a rule or law established by an organization or community to regulate itself, as allowed or provided for by some higher authority. The higher authority, generally a legislature or some other governmental body, establishes the degree of control that the bylaws may exercise. Bylaws may be established by entities such as a business corporation, a neighborhood association, or depending on the jurisdiction, a municipality. In the U.S., bylaw is the preferred spelling. In the United Kingdom, Canada, and some Commonwealth countries, the local laws established by municipalities are referred to as bylaws because their scope is regulated by the central governments of those nations. Accordingly, a bylaw enforcement officer is the Canadian equivalent of the American Code Enforcement Officer or Municipal Regulations Enforcement Officer. In the United States, the central government has no direct ability to regulate the scope of the laws passed by the municipalities. As such, terms such as code, ordinance, or regulation, if not simply law, are more common. Etymology: the Oxford English Dictionary indicates that the origin of the current modern use of the word is not clear. One possibility is the earliest use of the term, which originates from the Viking town law in the Dana law, wherein by is the Old Norse word for a larger settlement as in Whitby and Derby. However, it is also possible that this usage was forgotten and the word was reinvented in modern times through the use of the adverbial prefix by giving the meaning of subsidiary law or side law. In either case, it is incorrect to claim that the origin of the word is simply the prepositional phrase by law. Municipal bylaws. Municipal bylaws are public regulatory laws which apply in a certain area. The main difference between a bylaw and a law passed by a national, federal or regional state body is that a bylaw is made by a non-sovereign body, which derives its authority from another governing body, and can only be made on a limited range of matters. A local council or municipal government gets its power to pass laws through a law of the national or regional government which specifies what things the town or city may regulate through bylaws. It is therefore a form of delegated legislation. Within its jurisdiction and specific to those areas mandated by the higher body, a municipal bylaw is no different than any other law of the land, and can be enforced with penalties, challenged in court, and must comply with other laws of the land, such as the country's constitution. Municipal bylaws are often enforceable through the public justice system, and offenders can be charged with a criminal offense for breach of a bylaw. Common bylaws include vehicle parking and stopping regulations, animal control, building and construction, licensing, noise, zoning and business regulation, and management of public recreation areas. Bylaws in Japan. By Section 94 of the Constitution of Japan, regional governments have limited autonomy and legislative powers to create bylaws. In practice, such powers are exercised in accordance with the regional autonomy law. Bylaws therefore constitute part of the legal system subordinate to the Japanese constitution. In terms of its mandatory powers and effective, it is considered the lowest of all legislation possible. Such powers are used to govern the following: location of the seat of government of the prefecture, frequency of routine meetings, number of prefectural vice-governors and vice-village leaders, number of staff attached to administrative bodies governed, placement of regional autonomous areas, regulation of certain municipal monies, placement, maintenance and removal of public facilities, appointment of subordinate officers by the prefectural governor. From the Japanese Wikipedia, United Kingdom. Australia. In Australian law there are 5 types of bylaw, and they are established by statute. State government authorities create bylaws as a type of statutory rule under an empowering act, and are made by the state governor. Local government bylaws are the most prevalent type of bylaw in Australia, and control things from parking and alcohol in parks to fire regulations and zoning controls. In New South Wales these bylaws are called ordinances and zoning controls are called environmental planning instruments created under the Environmental Planning and Assessment Act. Numerous specific institutions, including universities, are also empowered to make bylaws by their establishing legislation. Bylaws of a company or society are created as a contract among members, and must be formally adopted and/or amended. Strata title was developed in Australia, and bylaws of body corporate are also empowered by state legislation. These are main type of bylaw most people come into contact with on a regular basis, as they control what people in strata title housing can do in their own homes. The most well-known of these is the No Pets and Flats rule. Corporate bylaws. Corporate and organizational bylaws regulate only the organization to which they apply and are generally concerned with the operation of the organization, setting out the form, manner or procedure in which a company or organization should be run. Corporate bylaws are drafted by a corporation's founders or directors under the authority of its charter or articles of incorporation. Bylaws widely vary from organization to organization, but generally cover topics such as how directors are elected, how meetings of directors are conducted, and what officers the organization will have, and a description of their duties. A common mnemonic device for remembering the typical articles in bylaws is nomomicpa, pronounced nomomi, CPA. It stands for name, object, members, officers, meetings, executive board, committees, parliamentary authority, amendment. Bylaws generally cannot be amended by an organization's board of directors. A supermajority vote of the membership, such as 2/3 present and voting or a majority of all the members, is usually required to amend bylaws. In parliamentary procedure, particularly Robert's Rules of Order, the bylaws are generally the supreme governing document of an organization, superseded only by the charter of an incorporated society. The bylaws contain the most fundamental principles and rules regarding the nature of the organization. It was once common practice for organizations to have two separate governing documents, a constitution and bylaws, but this has fallen out of favor because of the ease of use, increased clarity, and reduced chance of conflict inherent in a single, unified document. This single document, while properly referred to as the bylaws, is often referred to as a constitution or a constitution and bylaws. Unless otherwise provided by law, the organization does not formally exist until bylaws have been adopted. Union bylaws. In some countries, trade unions generally have constitutions, which govern activities of the International Office of the Union as well as how it interfaces with its locals. The locals themselves can set up their own bylaws to set out internal rules for how to conduct activities. In other countries, such as the United Kingdom, union bylaws are sometimes a subset of the Union unregistered trademark's constitution or implement the union's rules in more detail. See also, private governance, references.